number 2020 CR 85, captioned State of Kansas versus Saul Rodriguez. Would the parties announce their appearances, please?
May it please the court, Your Honor, the state of Kansas appears by Crystalline Oswald, Deputy District Attorney.
May it please the court, defendant appears through counsel David Matthews.
All right. We are here for a plea hearing today. Mr. Rodriguez, we talked a little bit about these questions I need to ask you. Can you hear me okay?
Yes, sir.
Okay. So before I can ask you these questions, I need to have you sworn in. So if you could raise your right hand, my court reporter will swear you in.
Okay.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, go ahead and put your hand down, Mr. Rodriguez. Can you tell me how far did you go in school?
The secondary.
Secondary school, okay.
Yeah. High school.
Now English is not your primary language, is that correct?
That's correct.
Can you read and write English okay?
Probably about 75%.
All right. Now, I'm going to pull up here in a little bit what's called the plea petition. Let me go ahead and do that now. No, that's not it. I had it open. Give me 1 second. Ah. All right, can you see that document I just put up on the screen?
Let's see. Yeah.
All right. Did you and Mr. Matthews have a chance to go over this document?
Yeah. Yeah.
And were you able to read it or have Mr. Matthews answer any of your questions about it?
Yeah. She's reading, and I just asked me about yes or no.
Okay. All right. And I see there's a signature there where it says defendant. Is that your signature?
Yes, sir.
Okay. All right. Now you understand. Let me ask you this. I know you're in custody, but as you sit here today, are you under the influence of any alcohol, drugs, or prescription medicine that might keep you from understanding what we're doing today?
No, I don't take any medicine.
Okay. You feel like your mind's clear today?
Yes, sir.
All right. Do you know what you're charged with?
They told me before, and it's look like battery, something like that. The last time, yeah.
The original charges in this are what's called aggravated indecent liberties with a child.
Okay.
Did you have an opportunity to go over and talk with Mr. Matthews about what you're charged with?
Not really.
Judge, I did talk to him about what he was charged with.
Okay.
If we need to do a breakout room, I can go over that with him.
Was there a preliminary hearing in this case?
No.
No.
No. Okay, we need to do that too today. Mr. Matthews, do you think you need a moment with your client here?
Just a quick moment, Judge, just to be sure.
We will make that so. Let me stop the share. There you go.
Thank you.
Judge, did you receive the plea petition yesterday?
Yes.
Okay, he's the second defense attorney that I've missed an email from. Jeff Liker sent me one and it finally sent to me about 2 days after he sent it. So I'm wondering if the same thing's going to happen with Dave.
Probably, yeah. No,
Yeah.
I received the first one that he
Okay.
sent out.
I've checked my junk email and everything. I'm not sure, but Jeff, like I said, Jeff did the same thing for a plea earlier this week, and I didn't get it until yesterday, and the plea was on Monday, so I'm not sure what the issue is. I'm told we're getting updates to our computers this weekend, so maybe that will fix it.
Yeah, that'll probably make it worse. That's been my impression.
Yeah,
Every time
unfortunately.
I get an update, it works. You know, I wish on these live streams that you had the ability to pause. You either have to end it
Yeah,
or keep going. So,
that's interesting.
yeah. All right, we are back. Are we ready to proceed, Mr. Matthews?
Yes, Your Honor, I believe he understands now.
Okay. So, we're back on the record. Parties and appearances are same as previously announced. Mr. Rodriguez, your attorneys talked to you for a while now. Did it help refresh your memory of what the original charges in this case are?
Yes, Your Honor.
Okay. And you know that you don't have to change your plea from not guilty to guilty. If you wanted a jury trial on those charges, you have a right to that trial. You understand that?
Yes, sir.
All right. At that trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You wouldn't have to prove anything yourself. Mr. Matthews would assist you through that trial. He would cross-examine, confront all of the state's witnesses, all of their evidence. He could call any witnesses you wanted called. And you could testify at that trial. But you also would have a right not to testify. And if you decided not to take the stand, the state couldn't try and use that against you to argue that you must be guilty for not taking the stand. You understand all that?
Yes, sir.
And if at the end of that trial, there was a conviction, you would have a right to appeal that conviction to the appellate courts. If you didn't have money to do that, a lawyer would be appointed to do it for you. Do you understand that as well?
Yes.
Now, if we go forward with this plea, you're going to be giving up all of those rights that I just talked about. There's not going to be a trial of any kind in this case. You understand that?
Yes, I understand.
All right. So I had up earlier this plea petition. I'm going to pull it back up if I can find it again. All right. It says in here that the plea petition is as follows, that you're going to be pleading to 2 counts of reckless aggravated battery, which are severity level 5 person felonies, that the parties are going to agree to recommend to the court 120 months for a sentence, running the counts concurrently. Is that your understanding of the entire plea agreement?
Yes.
All right. Has anybody promised you anything else to get you to plead guilty today?
I just say plead guilty, and
Has anybody promised you anything other than that agreement that I just went over with you to get you to plead guilty today?
no.
All right. Has anybody placed any force or threats against you to make you plead guilty today?
No.
All right. Now I see here that it says that their parties are going to be recommending a sentence of a particular length of time. You understand, well, I'm going to listen closely to everybody's recommendations, that I'm not bound by them, and I can give you any sentence that the law allows me to give you. Do you understand that?
Yes, sir.
All right. Is there an understanding what the parties believe Mr. Rodriguez's criminal history?
Yes, Your Honor, we believe him to be a criminal history A.
Okay. Mr. Matthews,
Your Honor, I had thought he was a criminal history B.
B. All right. Well, Mr. Rodriguez, here's how it goes. I'm going to be ordering a pre-sentence investigation in this case, and it's going to take a deep dive into your criminal history so that there can be a sentence on the pre-sentence investigation that you're presumed to get. All right. As we sit here right now, what I have to do is presume you have the very worst criminal history possible so that I can advise you what the maximum that anybody can get for this crime is, okay?
Okay.
All right, and the maximum is 136 months in prison, a fine of $100,000 with post-release supervision duration of 24 months. Now, is that the maximum for one count of this, or is that combined one count with the other count as an I?
It's one count, Your Honor. 136 is an A, aggravated
Okay.
5.
That would be count one. The maximum, I don't have my grid here in front of me. What is the high box on a 5I?
34, I believe. Give me a
Okay,
second. I'll pull it up. Yes, Your Honor, 34.
so the maximum for count one would be 136 months. The maximum for count two would be 34 months, and those could be run consecutively to equal 170 months. Do you understand that?
Yes, sir.
Okay. Do you have any questions about anything you and I have gone over today?
No.
All right. Mr. Matthews, do you know any legal reason why your client should not plead?
No, Your Honor.
As to count one of the amended information, which charges you with reckless aggravated battery, a severity level 5 person felony, how do you plead, guilty or not guilty?
Guilty.
As to count two of that amended information, charging you with the identical crime, how do you plead, guilty or not guilty?
Guilty.
All right. Now, Mr. Rodriguez, I'm going to ask the state to tell me what they think the evidence in this case would be. I want you to listen closely because when they're done, I'm going to ask you if that's what happened, okay?
Okay.
Ms. Oswald.
Thank you, Judge. And this is an instance where the defendant was originally charged with off-grid crimes for sexual assault offenses. And it's for the benefit of the bargain to him that he's accepting a plea to a reckless aggravated battery. I've been back and forth about whether or not a reckless aggravated battery could bear out by the facts that I'm going to review. But as I always do in every case that's like this, I will review the affidavit and the facts that would have been presented if he had gone to trial on the original charges. Ask Your Honor to find that those would be sufficient if he had gone to trial, and that is that he's accepting this plea for the benefit of the bargain.
Okay.
The general facts are from last summer of 2019. In June and July of 2019, the young lady who's the alleged victim in this case, her initials are DYN as in Nancy, came to a report desk and reported some inappropriate actions by the defendant. It should be noted, Your Honor, that this incident that she's talking about, these incidents that she relies on happening when she was 8 years old in 2011, were occurring at the same time for the previous convictions that he was sent to KDOC for. Certainly, if she had disclosed at the same time that others had disclosed against him, those likely would have been rolled into one case. That's part of the reason for the plea agreement that we came to. And so I'll kind of explain that. She explains that in 2011, she was around 8 years old. She gives a variety of incidents that happened, a lot of them being in Kansas City, Missouri. But specific to Kansas City, Kansas, she indicates that there was a church that they used to attend that was located at 948 Central Avenue here in KC, Wyandotte County, Kansas. It was called Casa de Dios, D-I-O-S. And she indicated that many times he would pick her up to take her to the church or take her from the church, and that incidents would happen while he was assisting her. She describes a variety of instances where they have sexual contact, all of which would certainly have qualified for lewd fondling. Him carrying her into a bedroom and touching her body, licking her breast, watching her in the shower, washing her while she's in the shower, those types of indications. These are the incidents that she talks about that happened specifically in KCK. She did not tell anybody at the time that they happened. She indicates at her Sunflower House interview that the reason she didn't tell anybody is because she didn't know it was wrong. She also didn't have any idea that anything was going on with anybody else at the time that it happened. She learned subsequently about the allegations that he was convicted on previously and still did not disclose at that time. But once she turned 18, or around the time she turned 18 last year, she spoke to her mom about it and they chose to disclose it to law enforcement then. I think that her conversation about the number of times that he would have touched her, made her touch his penis so that she could feel his penis, and those types of things, as well as the shower incidents, certainly would qualify for 2 counts at least of aggravated indecent liberties, which he was previously charged with. We have agreed to allow him to plead to level 5 reckless aggravated batteries. That is at basically the express wishes of the victim after speaking with her and her mother about how they would like to see this case resolved, and due in part to the fact that certainly if she had disclosed at the time that the other children disclosed, her case would likely have been scooped up into that one. And he's already served his time on those cases and is now looking at serving another at least 120 months in this case, if Your Honor follows the recommendations of the state. I also believe that he is likely to be deported. I think that's in the plea petition, but I cannot remember whether or not he is somebody subject to deportation. Certainly, Mr. Matthews could speak on that better.
Right. All right. And Mr. Matthews did mention earlier that he believed that Mr. Rodriguez was subject to deportation after this sentence. All right. Mr. Rodriguez, you heard what the prosecutor had to say. Is that what happened in this case?
Yes, sir.
All right. Thank you. I will find the defendant has freely, voluntarily, and intelligently entered into this plea. He understands the nature of the charges and the consequences of the plea. There is a sufficient factual basis for a finding of guilt, and I will in fact find if in any way the facts described by the state, which would have supported the original charges, do not support a finding of a reckless ag battery, that it is due to the defendant benefiting from the bargain to make these to make the facts fit the charges as he has pled. So I will in fact find that he is guilty of 2 counts of reckless aggravated battery, both severity level 5 person felonies. I'm going to order a pre-sentence investigation and continue sentencing pending receipt of that report. I have been setting my sentencings these days in the first couple of weeks of January. I have a 10 o'clock available on January 15th. Mr. Matthews, would you be available then?
Yes, Your Honor.
And Ms. Oswald?
Yes, Judge.
Okay. I will set the sentencing for January 15th at 10 o'clock. Mr. Matthews has already sent the PSI request over to probation, so they should be on it. Mr. Rodriguez, I have to advise you, as a convicted felon, it's prohibited for you to own or possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons, okay?
Okay.
It's a registration offense. It requires, once you are released, for you to register for the rest of your life as a offender. So you need to, within 3 days of your release from prison, assuming that you are in the country, you have to register in the county in which you are residing as an offender. Failure to do so would cause more charges to be filed, okay?
Okay.
All right. Anything else that I forgot for the record today, Ms. Oswald?
No, Your Honor.
Mr. Matthews?
No, Your Honor.
All right, thank you all. We will see you on January 15th at 10 a.m. Paula, thank you for all your help today, and have a great weekend.
You're welcome, Judge.
Thank you.